Hi, my name's Brent Selwyn, and today I'd like to talk to you about 7 things you need to know about making a will. A little bit of background about me. I've been in the law for going on 29 years. I'm a partner here at Kannangara Thomson, which is a full-service law firm offering specialist service, in my case, in asset protection and estate planning, which involves all things to do with wills, enduring powers of attorney, family trusts, and the like. But today, we're going to concentrate on making a will. First thing, talking about choosing your trustees wisely. So who are the trustees? Well, the trustees are the people that you name in your will who will manage your affairs once you've passed on and follow your instructions as set out in the will. For that reasons, it pays to choose your trustees wisely and to choose people whose ability and business acumen you trust implicitly. Something that people often don't realise is that the trustees have the overriding say in what happens to your body. So it's the trustees who decide. If they know your wishes and it's not in the will and you want to be cremated or buried, it's up to the trustees to follow your instructions. In your will, you might be aware, if you have minor children under the age of 18, then you can use your will to appoint what we know as a testamentary guardian or guardians. Now obviously, it probably goes without saying that these are also people whose judgment you should trust to do the right thing by your children and to make sure that wise decisions are made for your children about things such as where they live, with whom they live, what school they go to, things that might have been important to you in your life, like a religious upbringing. Contrary to popular belief, it's not a given that your children will live with the guardian you nominate in your will. For example, you might have your parents as testamentary guardians, but it might be your wish that your children would live with one of your siblings. It might be more age appropriate for your children to live with, say, a sibling rather than an aging parent. And a point to note is that it usually pays to make sure that your trustees are separate from those people who are your guardian or guardians. Now, without wanting to seem offensive, that's because the trustees control the purse strings, and if they are the same people as the guardians, then it's very easy for the guardian to get their hands on funds if they need it, whereas it's better, in our opinion, for the guardians have to go to the trustees to actually ask for money that they might require for the welfare of the children, say for an overseas field trip or for private schooling. In your will, you can give funeral directions. Not everyone tends to do this, but you can. You can say, for example, how you would like your body to be disposed of by cremation or burial. You can take that a step further and leave instructions about the undertaker you want used, the celebrant, the place of the service, even the music to be played. And as I said, where your body or remains will be buried or interred. From a practical perspective, however, it's better to ensure that your trustees know your wishes and your family members know your wishes, because in our experience, when someone passes away, it's not always the first thing that people do to ring the lawyer. Just as an aside, the whole reading of the will thing is really an Americanism and very seldom happens in New Zealand. Another little known point is that you can have wills in different countries. So if, for example, you have assets in the UK and you also have assets in New Zealand, you can have more than one will as long as your will says this relates only to my New Zealand-owned assets. So it's very important that you don't then do a will somewhere else saying, I revoke all prior wills made by me, because you will revoke all wills made in any country. So the alternative, if you only have, say, one will in New Zealand, but you have historical assets in the United Kingdom, is that you obtain probate, or your lawyer obtains probate of your will in New Zealand, and then sends that will to a lawyer or trustee company in the United Kingdom, who then reseals the probate in their jurisdiction, and then that law firm can deal with your assets which are owned in that other country. In your will, you can make specific bequests. So that's where you leave an item of belonging or maybe a certain amount of money to a certain specified people. So if you've got something precious to you like a wristwatch or some golf clubs or whatever, and you want to leave them to one of your children, the will is the chance to do that. Same for collectibles. and money. And now obviously that can be to a person or an organisation. You could leave a bequest to a trust or a charity that's near and dear to your heart. It's important to note that if the recipient of the money is also a trustee of your will, that you say in the will quite clearly that it's left to them for their own use and benefit, so that it's not confused with the fact that it might be left to them in their capacity as a trustee to do something else with that money or that item. Another little known thing about wills is that you can leave a life interest to someone. This is very common in circumstances with blended families or de facto relationships, second time around relationships, where each party perhaps has children by another relationship or marriage, and rather than leaving an asset outright to your partner, you might want to leave them, for example, the right to live in your share of a property that you own jointly for the rest of his or her life, or for a specified period, a number of years, or until a child attains a certain age, for example. Usually a life tenant would have to pay the outgoings, such as the rates, the insurance, and any mortgage on the property. And on the death of the life tenant, the survivor of you, the proceeds from the sale of your share would then go to the intended final beneficiaries, who more often than not would be the children of a prior relationship. So that's a way of trying to look after all parties' interests after you've passed away. Another thing that you can do, the seventh thing, last thing talking about today with wills, is you can create a thing called a testamentary trust in your will. So that there's no magic in that term. It's just a will which is created in your, a trust which is created in your last will and testament, as distinguished from a family trust that you form during your lifetime. This is a trust which you establish in your will. They are commonly used for where you have, say, a child who has special needs, or maybe has had an addiction, and it's inappropriate for that child to be given a large amount of cash. The money is then, or their share of the estate, is then left with your trustees, who can be given the task of looking after that child's needs during their lifetime. So if, for example, the child wanted funds for the purchase of a home, and that was deemed appropriate, the trustees could use some of their interest in the capital of the testamentary trust for that purpose. More commonly, with special needs children, there is a limit on the amount of cash they can receive and still get a benefit from the state. So trustees can make sure that funds are made available in small quantities regularly for that child's benefit. On the death of the child who is the subject of such a testamentary trust, usually the remaining capital, if any, and any interest which is accumulated will be divided between other children of a relationship. What to do next? Well, that's the 7 things you need to know about making a will in New Zealand. We invite you to contact me, Brent Selwyn, at KT Law. You can either email me on the email address brent@ktlaw.co.nz, or give me a call on 9436 to arrange a complimentary phone appointment to discuss your will requirements. Thank you for your time today.